The honors will go live in 5, 4, 3, 2, 1.
Your Honors, good afternoon.
Good
This
afternoon.
is a continuation of the public panel interview by the Judicial and Bar Council of candidates vying for the position of Associate Justice of the Court of Appeals, the Court of Tax Appeals, and the Sandigan Bayan. The first for interview this afternoon will be Judge Emmanuel A. Silva, a candidate for the position of Associate Justice of the Court of Appeals and the Sandigan Bayan. May I request Judge Silva to please raise your right hand so that I can administer the oath? Do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview by the Judicial Bar Council?
I do.
So help you God. Thank you, Judge.
Thank you po, sir.
To interview Judge Silva will be the Honorable Franklin J. De Monteverde. Judge De Monteverde, sir.
Okay, thank you, Attorney Ed.
Thank you, sir.
Good afternoon, sir.
Good afternoon, Judge Silva. I still can't see you. Okay. Judge Silva.
Yes, sir.
Is this your first time to apply for the Court of Appeals and the Sandigan Bayan?
No, sir. This is my third, but I was interviewed once. Then the second one was still within the 1-year period, so I was no longer interviewed. And so this is my third time to apply, sir.
When were you interviewed the second time?
That
Last
was
year?
last
Only
year.
last year?
Last year, sir. Last year.
You applied for the 8 vacant seats Court of
That's
Appeals?
correct, sir. That's correct, sir.
4 were already appointed and 4 are still hanging. Okay.
Yes, sir.
So, okay. Judge, from your last interview, have there been any changes in your credentials or in your PDS that is worth mentioning?
None, sir, because it was just last year. No substantial changes.
Okay. Just would like to ask you some questions na lang, a few questions because we interviewed you last year only. Medically, you have a mean platelet volume, which is high, and there is a blood trace urinalysis mo.
Yes, sir.
How do you feel medically?
Sir, I am physically fit, and actually, I exercise 4 times a week. Most of the time I do brisk walking and cycling, and I don't feel anything that is bad at present with respect to my health.
Okay. But your chest X-ray shows that you have atheromatoous aorta.
That's correct, sir. I
know
consulted.
What this is all about?
Yes, sir. I consulted my doctor about it, and he told me that it's just it's a normal on those person reaching around 50 years old. It's just like the hardening of the arterial wall. So it's starting to collect some plaque on the arterial wall. But I do care for my health. As in fact, if you notice, I'm not my physical features, sir. I eat vegetables and fish. I don't eat too much meat.
Okay.
And I exercise a lot.
Judge, you are now the presiding judge of Branch 4 in Mariveles, Bataan.
Yes, sir.
And for how long have you been there?
This coming April 1, I'll be on my 8th year.
Okay, 8th
but
year.
I became also as an MTC for 6 years. And for RTC, this coming April 1, I'll be on my 8th year, sir.
And for how long have you been with the judiciary?
All in all, so 6 plus almost 8, so 14, sir. 14 years, this coming April 1, to be exact.
What's your caseload now?
My caseload is 162 or 64, 164 as of end of the November. When I assumed my responsibility as a presiding judge of that court, my caseload was 1,493.
Okay.
So it's just now 162, sir.
Judge, you passed the bar in 1996, but you passed it on your third try. Now, can you cite some credentials in your favor that would somehow compensate this issue?
Thank you for that question, sir. Ever since I was a child, I already encountered a lot of challenges. But one thing is that I rose from those challenges.
Mm-hmm.
And at that time, or as I said, at a young age, I was already working. Was already helping my parents in the market, selling some things, and then during my college days, even undergrad, I was already working student, sir, and up to law. And so what happened then was that in the bar, I was only given around 1 month to review. Then I took the challenge, but unfortunately I didn't make it. But I rose to the challenge, sir. That's why I'm here. I'm not shy about it, because I want to show that as a person, I have a strong faith in my capability, that I can rose to the challenge. And the compensating, sir, is that I was working then at the bank. I became a bank counsel, and then I was sent to study abroad. I took Master of Law in Commercial Transaction. And then
Where in the States, Judge?
in San Francisco, in University of San Francisco, sir. I studied
Did you
there.
earn some credits for it?
Yes, sir. I graduated from that course, Master of Law, major international commercial transaction.
Okay.
And then I also took a Master in Public Management, and I graduated from that course.
What school?
Ateneo de Manila, sir, School of Government.
So
And
in school,
Yes,
Judge, did you earn some awards? Were you given some awards, or you earn some credentials that would help, that would compensate for this three times?
Yes, sir. During my undergrad, I was an academic scholar. I was a dean's lister, sir, despite I was working student.
Okay.
And then in the School of Law, because of the heavy load plus the work, I was working in private in a bank. And so I was not able to get or to secure an honor degree.
Okay. You should teach at any of the law schools?
That's correct, sir. I teach commercial law in Manuel L. Luis Quezon University School of Law.
Until now, Judge?
Yes, until now, sir. I also taught in University of Manila.
Mm-hmm.
Yes, sir.
You are being recommended by Honorable Adolfo Ascuna. How well do you know him?
Yes, sir.
How well does he know you?
Yes, sir. As I indicated, sir, in my application to prove my integrity, there was an instance when we attended a seminar about the continuous trial rule, and then right after or we were billeted in Novotel Hotel, and supposedly my companion judge who did not sleep in that room. We were supposed to share the same room, and then after that, the seminar would end at 5 o'clock, but we were told to already take all our things from the hotel and just leave our things at the seminar room. And then I look underneath the bed, and I saw a box containing jewelry, sir. And then I immediately tell to myself that I have to surrender this to the front section. And then I went, before going down at the front desk, I first put my things at the seminar room, and unfortunately I met my supervisor, DCA Raul Villanueva and asked me if I already took my lunch. I said, no, not yet, sir, because I have to surrender this to the front desk, this jewelry. And I show the box. And fortunately, and at that time, retired Justice Adolf Ascuna was there. Our Chief Justice, Justado Peralta, was there. And DCA Raul Villanueva was also there. And then they saw that the pieces of jewelry, and then I turned it over to the front desk, and I was glad. I was happy, sir. I was happy that Chief Justice Peralta mentioned my name before all the judges of Region 3 and fiscals of Region 3, Region 3. He told in the seminar that I am the epitome of integrity of a judge, that despite I am the only person in my hotel room, I still surrender that jewelry. And he even said that it's worth around 1 million. And that was the very particular incident that Justice Ascuna was able to know my personality, sir.
Okay,
Aside,
Judge.
of course, from the Chancellor Pilja that
Okay.
I regularly attend seminars.
Okay. Judge, if you were asked to summarize, what specific part in your 3-page intent letter would you want to highlight? Your professional credentials, your independence, or your story with the Chief Justice?
The integrity, sir. The integrity.
Integrity.
Because
Okay.
it's my policy that intelligence can be acquired, sir, through
Mhm.
constant exposure, readings. It can be acquired, sir. But
Okay.
integrity, it's either there or it's not there.
Okay, Judge. Let's go to your SALN. Are you the one who prepares your SALN?
Yes, sir. Yes, sir. That's correct.
You are married.
Yes, sir. My wife works at the Bangko Sentral ng Pilipinas.
So she's also a government worker.
Yes, sir. That's correct.
Now, how do you file your SALN? Joint or
We file it
separate?
separately, sir.
So that is the reason why your wife has not signed your SALN since 2008?
Yes, sir. We file separately. We sign separately, sir.
Okay. Now, from your net worth amounting to more or less 7 million in 2010, it ballooned to 21 million in 2011, only in 2 years' time. Please explain.
Yes, sir. A part of that, my sister, sir, went to Japan, and then she is a widow. She's a widower, and then her husband, when her husband passed away, a Japanese national, she was able to get pension, and then being the only lawyer in the family, and she again went back to Japan, she entrusted to me a part of her money, sir. So not
Oh.
all of them are mine.
Okay. How much does your sister have in your deposit?
Around 10 million, sir.
10 million.
Yes.
Okay. Now, also in 2017, from 28 million, it increased to 32 million in 2018. And later on, in 2019, increased to 35 million. Again, this involves money from your sister?
Yes, sir. It's still with me. Because
until now.
Yes, until now, sir. And
Ah.
also, sir, being in a bank, I was able to learn the value of the importance of savings.
Mhm.
And even before I was a lawyer, I already invested in real properties. I purchased projects that are to be built, no, and then sell it, sir.
Okay.
Yes, as an added income.
So you made profit from it.
Yes, sir, that's correct.
Okay.
Reselling.
Mhm.
And
Okay.
then I put some of the savings in bonds, commercial bonds, sir.
Now, on current events, Judge, no? A man in Australia checked into a hotel and asked the staff to look after his bag, which turned out to contain 7.68 kilograms of the drug called Fantasy. Well, the penalty for that kind of offense is 1 million Australian dollars and life imprisonment. The man just received a suspended sentence over the exceptional circumstances of the crime, which the court said was unusual in the extreme and stupid behavior. If that was committed in the Philippines, what charges should be filed against the man and the staff of the hotel who looked after the bag that contained drugs, if any?
Still, sir,
Yes.
under Public Act 9165, illegal possession of dangerous drugs.
Okay.
And then, if the accused is guilty, he would be penalized in view of the weight of the illegal drugs. He may be liable for life imprisonment or reclusion perpetua or life imprisonment, as the case may be, based on the weight of the illegal drugs, sir.
You were connected once with a commercial bank, Judge?
Yes, sir. I work with the bank for around 16 years.
16 years.
Yes, sir. As a working student and then as a lawyer, all combined.
Okay. Now, I'll ask you a few questions before
Yes,
I wind up my interview of you. This has something to do with appeals, no?
Yes, sir.
Considering that you are applying for a seat there. Now, are the commercial arbitration awards reviewable under Rule 43?
Yes, sir. It's specifically provided under Rule 43. Arbitration is it's considered, sir, as quasi-judicial body, and
Okay.
among those administrative bodies is the arbitration.
Mhm.
Just like the commercial international arbitration,
Mhm.
covered by the jurisdiction of the Court of Appeal, sir, under Rule
Okay.
43.
Kindly review Fruhoff Electronics versus Technology Electronics, November 23, 2016. Huh?
Yes, sir.
Okay. Now, may appeal from the SIA, the Construction Industry Arbitration Commission, raise a question of fact or mix questions of fact and law under Rule 43?
Sir, all Rule 43, as I understand, all Rule 43 to the Court of Appeals, it may involve questions of fact, question of law, or both.
Mm-hmm.
Then if it is elevated under Rule 45, only question of law is involved, except for exceptional circumstances.
Okay.
But that one is before the Supreme Court, Rule 45. But Rule 43, Court of Appeal, sir.
Okay. Review further Metro Bottled Water versus Andrada Construction, 6 March of 2019. Okay.
Yes, sir. Thank you for that, sir.
Now, what is the remedy of an aggrieved party from a decision of the Ombudsman in an administrative disciplinary case?
Yes,
Aggrieved
sir.
party. Okay.
Yes, sir. In the case of Fabian versus Desierto, the Supreme Court held that with respect to administrative cases, the jurisdiction lies with the Court of Appeals.
And yes.
Yes, sir, under Rule 43. And then
and
the
what should be
criminal
the
aspect,
petition?
it's petition for review, sir.
Okay.
Under Rule 43, petition for review.
Kung administrative disciplinary case, no?
Yes, sir. That's correct. If criminal.
Okay. What if it is a criminal case? What is the remedy of the aggrieved party?
The aggrieved party has to file under Rule 65, petition for certiorari before the Supreme Court with respect to the criminal aspect, sir.
Okay.
The resolution rendered by the Ombudsman.
My last question, Judge. What about the remedy if the Ombudsman exonerate respondents from an administrative liability?
It's not appealable, sir. It's not appealable. The only thing to do is file an original petition for certiorari under Rule 65 to the Supreme Court.
Okay, Judge, that was my last question. Thank you for your time.
Thank you very much, sir.
Good luck.
Thank you very much, sir.
Stay safe.
Thank you very much, Your Honor, Judge De Monteverde. Honorable Justice Noel Jimenez Tiham will be the next to pop on questions to Judge Silva.
Thank you, Attorney Ann. Good afternoon, Judge.
Good afternoon, sir. Good afternoon, Justice.
Concerning your SAL-N, you explained that the sudden increase in your network from 2010 to 2011 was money coming from your sister.
That's correct, sir.
Were you holding the money of your sister in trust, or was it given to you?
In trust, sir. In trust.
In trust. So, are there any documents to indicate the arrangement you had with your sister? And can
No,
you furnish the copy to the JBC?
Being a sibling, sir, we did not sign any document. She entrusted it to me because she knows that I handle her money properly. Because before, she also did that before, sir. Because she went for Japan to Japan for so many years already.
Does your sister have any children of her own?
None, sir.
None. Okay.
None.
So there's no document that would indicate that she can get back the amount given to you in trust. There's no document.
There's no document, sir. But as I said, it's again integrity. My sister knows me, and that's why she trusts me that much.
And the increase in your network from 2011 up to 2019, there is a gradual increase in your network, are all principally sourced from money given by your sister in trust. And you were mentioning about investing in real estate, you were saying?
Yes, sir. Yes, sir.
Did you declare earnings you made from the buy and sell of real estate? Did you
Yes, sir.
declare
I pay capital gains tax, sir. And
Okay.
also, I have bonds or commercial bonds, and that's why the interest that I get from those bonds are the monies that I spend. And then the salary that I receive from the Supreme Court, I save them. And then once they reach 1 million, I put them again on a commercial bond, sir.
So your network in 2019 is solely your network, because you said you do not file a joint SAL-N with your spouse, who is also a government officer.
Yes,
Correct?
sir. That's correct.
So this network of 35M is derived from salaries and wages, also the money given to you in trust, as well as gains out of the buy and sell of real estate.
That's correct, sir.
Now, Judge, can you tell me what are the remedies available to a third party, to a third person who is not a party to an action, but whose property is the subject of execution?
Yes, sir. As provided under Rule 39, we have what we call as terceria. That third person can file an affidavit, then submit it to the court and to the sheriff, stating under oath that he or she owns the property. And then, and then if the prevailing party still wants to pursue the writ of execution, the prevailing party may pose a bond to answer for the damage that third person may sustain. The other option, sir, is to file an independent action to preserve the right of that third person who owns the property and yet it was levied or executed by the sheriff.
What is the difference, Judge, between an adverse claim and a notice of lease pendants?
Yes, sir. Thank you for that question. Notice of lease pendants, from its word, there is a pending case already, sir. And then an affidavit would be filed by the one who wants to register to annotate it, attaching the copy of the pleadings. While adverse claims, sir, there is no case yet, but there is a strong possibility that the property may be disposed of. That's why the one who wants to register the adverse claim may immediately go to the Register of Deeds and cause the annotation of the adverse claim. So there's no case yet, sir.
In the case of Frabel Properties Corporation versus AC Enterprises, decided last month and penned by Chief Justice Peralta, the case made mention of what is known as a noise nuisance. What is your understanding of a noise nuisance?
Well, I haven't read that case yet, but this is just a guess, sir, that the one causing the annotation on its space has no valid reason or valid ground to annotate or to cause the annotation. I'm not sure, sir, but because I haven't read the case yet. But
Noise. Can you make an educated guess?
Noise.
Nuisance.
Noise, sir. So noise nuisance.
N-O-I-S.
Noise nuisance is just like, sir, the local government can immediately restrict
Can you
the
give an
said noise.
example can you give an example? Can you think of an example of a noise nuisance? You know what the nuisance is?
Nuisance, sir. Yes, sir. Example is that in a residential area, sir, let's say in a subdivision, and then there is a big generator put by a neighbor which is for industrial use, and it generates too much noise that it already it causes for the neighbors not to sleep well. And then that neighbor who owns that generator turn on the generator even at night.
What about a karaoke operated by your neighbor? Can that qualify as a noise nuisance?
I believe, sir. Yes, sir. That's why there is there's an ordinance or even a law prohibiting the karaoke even before the COVID. So I believe, yes, sir.
Is there a law or a empirical standard for quantifying a noise nuisance to the best of your knowledge and information?
Yes, sir. Yes, sir. There is a corresponding decibels indicated in the ordinance. Like, for example, sir, if the karaoke is being played or people are playing video okay outside of the house, or even inside, the windows are open, and so it really creates a disturbing noise. I believe, sir, because karaoke itself is not it's not illegal. one can play karaoke in the privacy of his or her own house as long as it does not distract the right of others.
What about an unscheduled street demonstration or protest without a permit, disrupting business within the area? Can they qualify as a noise nuisance?
I don't think so, sir, because in my readings of the constitutional law, the freedom of expression is being given one of the highest right of a person. So it may just be regulated, sir, but they cannot be stopped from their
No.
redress of grievances. That is their constitutional right, sir.
Talking about the Constitution, in your opinion, during this period of pandemic, which is more paramount, the physical, mental health of the citizens or the spiritual health of the citizens?
In this time of pandemic, sir, the safety of the people is more paramount than religious freedom. I read somewhere that in the case of Espinosa versus Montano, it's a foreign jurisprudence. The right of the people for their safety is more paramount than religious freedom because people can still exercise the religious freedom even not inside the church. God is everywhere. So they can still exercise there.
What about the wearing of a mask? Is there scientific data that it protects individuals effectively from transmission and infection?
Yes, sir. Yes, sir. As I heard in the
According
speech,
to the media.
no,
According
sir.
to the media.
Speech of Dr. Anthony Fauci. No, he mentioned that the effective way of controlling COVID is through the use of face masks and then observing the distance of around 2 meters, 1 or 2 meters. So he's a doctor. He's the head of the infectious disease in the U.S. So there's a scientific basis on that.
But how come scientists are saying that even if you get inoculated by a vaccine, you still have to continue wearing a mask? So, what is the scientific explanation for that?
Well, I guess, sir, because other people may not have been vaccinated yet, and
No, no,
then,
no. The scientist said even with the vaccine, even if you have been inoculated already, it should not prevent you, or it should not compel you not to wear a mask just because you have been inoculated. You have to continue wearing a mask. So what is the scientific explanation for that?
my answer, sir, is that vaccine itself is not 100% sure to cure COVID. It's around 90 something, 92, 94. So there's still a 6% or something with respect to the efficacy of the vaccine. So in order to ensure that people would not be placed on danger, even those people who had already been vaccinated must still exercise health protocols such as wearing face mask.
All right, Judge, can you tell me if a judge's decision on whether there was a violation of the right to a speedy trial subject to review?
Right to speedy trial subject to review.
Supposing a judge makes a declaration there was a violation of the right to a speedy trial, is that reviewable by a higher court? And
So, yes, sir.
so what is the remedy?
So if the who is the one complaining, sir? The litigants or the judge? If I may, sir.
Yes,
If I may ask.
the judge has already made a declaration in a case that there was a violation of the right of a party to a speedy trial.
Yes, sir.
Now, the other party does not agree with that. Is that reviewable by a higher court?
So if there is a decision rendered by the judge, sir, if there is a decision rendered by the judge to that effect, under the principle of the power of judicial review, sir, if there is a grave abuse of discretion based on that decision of the judge on that aspect, it is still reviewable, sir.
Through a what legal remedy?
Sir, petition for certiorari under Rule 65, original
Judge,
action.
what is the doctrine of indelible allegiance in international law? What is the doctrine of indelible allegiance? You took masters
Yes,
abroad,
sir, but
correct?
it's in commercial transaction. It's something like international law. But
Yeah.
indelible allegiance, I haven't read that decision, sir. But I'll just make a wild guess.
Yeah.
It's
Go
a
ahead.
yes,
Go ahead.
yeah. It's an allegiance of the person to his or her own state, and then indelible. Well, it is. Well, I cannot answer that, sir. The word indelible.
You just research on that. What is the law on public bidding, Judge? What is the law on public bidding?
Yes, sir. A law on on public bidding is that the any project of the government must pass through a competitive bidding. The one who offers the lowest amount normally wins, sir. So, okay, competitive bidding, that's the word, sir.
Is the lowest bid necessarily considered the best bid?
Personally, sir, I don't believe. That's why we have a problem. We always take into account whatever is the lowest bid, but we don't rely too much on the quality. I don't subscribe to the lowest bid because there are so many projects that may be high in price, but we can be assured of the quality. But that I guess the problem is that in the law, the competitive bidding, whatever is the lowest amount of bid wins.
What is a Swiss challenge and why is it called a Swiss challenge?
Thank you for that question, sir. Switch challenge is that if there is a proponent, sir, just like in the case of San Miguel, the putting up of international airport in Bulacan. So a proponent proposes to the government to build that infrastructure, and then that project will be subjected to the evaluation study of the NEDA, and then the NEDA would also declare or invite other bidders or other proponents to match the project, the cost of that original proponent. And then if the other proponent is able to match that project, the original proponent is again, sir, given another opportunity to provide a higher or even match the one that has been submitted by the second proponent. With respect, yes.
Swiss? Why is it called a Swiss challenge?
That's what I have to admit, sir. I don't know the etymology why it is called the Swiss challenge.
All right. My final question is, traditionally, a judge who imposes a death sentence after rendering judgment of the death penalty breaks the tip of his pen. What is the reason for that?
Yes, sir. It's something emotional. So we trial judges, we encounter that often, sir. Even there is no death penalty. The death penalty has already been abolished.
That is not the question. The question
Yes, sir.
is, why is it that judges who renders a death penalty in courts, in countries where there is a death penalty, traditionally breaks the tip of the pen? What is the reason for that tradition?
I guess just to show that the judge studied the case well, and that as far as he is concerned, he does not want that to happen anymore. That's why he breaks the tip of his or her pen. It's just a guess, sir. I don't, yeah, I don't have any legal justification on that.
All right. Thank you, Judge, for your time and good luck.
Thank you very much, sir. Thank you very much, Justice.
Thank you, Your Honor. Justice Tiham. To interview Honorable Judge Silva next is Honorable Judge Toribio E. Ilaw Jr.
Thank you, Tonian.
Good afternoon, sir.
Good afternoon, Judge Silva. Take a breather, at least 30 seconds. And then take a deep breath. Smile. Yeah.
Thank you,
How
sir.
are you? How are you, Judge?
Very fine, sir. Although a little bit nervous.
Are my colleagues making it hard for you, asking questions?
No, sir. It's part of the job. It's part of the job. Actually, the questions are not that very difficult.
I'll make it,
as far as I'm concerned, but don't give me difficult questions, sir.
I'm going to give you just not hard, not too hard. All right. In your application letter, you demonstrated your probity and integrity through an anecdote wherein you found pieces of jewelry in your hotel room worth 1 million pesos.
Yes, sir.
It
was Chief Justice, our own Chief Justice himself, who said that in his speech, that in my approximate, the piece of jewelry is worth 1 million, sir. I just based it from the speech of our Chief Justice. He was not yet then the Chief Justice at that time, sir.
So was it normal for one, I guess, before leaving the room to check under your bed?
I don't know, sir, but
was it only normal that to look into personal properties in the drawer or in a place or places where personal things will be visible?
Normally, it's not usual, sir, but it did happen. That's why I showed the piece of jewelry, bracelets studded with diamonds, pendants, and the like. It's in the back. It's underneath the bed. Not that at the edge of the bed, but somewhere far at the corner. Perhaps it was forgotten by the guest.
Yeah, unless you hide somebody under the bed.
No, sir. Any person cannot get through under the bed. It's just like the case of Art Borjal versus President Aquino then.
Yes. In the case of a libel case.
Yes, sir. The fair comment.
So you just, Chief Justice then mentioned about worth 1 million.
Yes, sir. Yes, sir. He said, according to my estimate, it's valued around 1 million.
Don't you think that's expensive or more or less too low for you?
It's on the average, sir. Because I saw the pieces of jewelry. There were diamonds and gold. The box is not small. It's a little big. It's a little big, sir.
That's a question of demonstrating your probity, integrity. How about in discharging your duties as a magistrate? How would you demonstrate integrity and probity?
Yes, sir. As I decide, we judges, including me, sir, we just only rely on 3 aspects: the law, evidence, and jurisprudence. Nothing more, sir. Regardless of the personality appearing before our court. So we just dwell on those 3 aspects: law, evidence, or jurisprudence, sir.
And you have been with the regional trial court for how many years? 6 or 7 years?
Going 8, sir. This April 1, to be exact. Going 8. This April 1, next year. April 1.
Do you think you have contributed enough of your talents and skills in that post?
Yes, sir. Yes, sir. I just like a good soldier, I followed the continuous trial rule, the Speedy Trial Act, and now the newly passed amendment to the rules on civil procedure, which further shorten the time with respect to the resolution of the motions.
And what do you consider your greatest accomplishment as a trial judge?
My greatest accomplishment as a trial judge, sir, I was able to lower tremendously my caseload from when I assumed 1,493, it's just now 162. And then I dispose them without having to ask for extension, except when I initially assumed my function as a judge. But after a year, I did not anymore request for extension. I resolved all the motions and the decisions on time, sir. So just like a good soldier, I perform my job on that aspect, sir.
And what do you consider your toughest challenge as a trial judge?
My toughest challenge, sir, is that despite we're just doing our job, some litigants filed a case, an administrative case against me. But those cases were dismissed and it did not even reach an administrative case, only IPI or initial preliminary investigation. So but it's part of the job. We know that we cannot please everybody because it's not our job. So some litigants may have grudge against us. So that's the toughest, sir. Meaning we're doing our job and yet here we are. We have to confront, we have to face those administrative cases.
What are the areas for improvement
For
you?
areas for improvement, I guess, sir, that's areas of improvement. I just do my job, deciding cases on time, and then I cannot control litigants who may have a grudge against me. So I cannot answer indefinite, sir, the improvement, but because I'm just as I said, a good soldier for the judiciary, I just do my job based on the rules promulgated by our Supreme Court.
And why do you deserve a promotion, Judge?
Yes, sir. I believe that with my talent, I, aside from having been a municipal judge of RTC, I already have the experience when it comes to appeal. And then I teach commercial law. And then I had a master's degree in commercial law. So I guess I can contribute. I can contribute in the Court of Appeal, sir. I still have 17 years left for me to retire mandatorily. So I want to devote that 17 long years to the judiciary. Of course, I will no longer apply for the Supreme Court. It's just, sir, it's just for Court of Appeals that I want to dedicate myself until I reach the age of 70.
And why do you think you should be nominated over other applicants who took the bar exams only once or twice?
Yes, sir. Thank you for that question.
You're welcome.
Yes, other judges or a lot of judges or those who applied have the same qualifications or even better qualifications than me. But what I can state in this interview is that as I've shown in my application, as I've indicated in my application, the integrity, sir, is there. The fact that I followed the rules with respect to the accomplishment of the cases that need to be resolved on time, and that I am hardworking person, sir, and I just live a frugal life.
And what is your greatest failure? And what did you learn from it, Judge?
Failure, sir, I have a lot of failures, just like as I said in the bar, and but just like an ordinary person, whenever confronted with a problem, with a challenge, I have to rise up to that challenge, prepare to stand up, because I oftentimes I say to myself that it's not a matter of a person not going down, no, because one way or the other a person may fail, but what is important is that every time a person fails, he stand up to prove to the world that he can do it. So I just want to emphasize, sir, that I do my best. I study again. So to speak, I put up the pieces back again, and then rise up to the challenge.
All right, thank you. I don't know whether my colleagues had asked you this question because you're applying also as an Associate Justice of the Sandigan Bayan.
Yes, sir.
Are the decisions of the Ombudsman immediately executory? I don't know whether it's already been asked.
It has been asked, sir, with respect to the administrative case. In the case of Pabian versus Desierto, the one that should be filed is the petition for review before the Court of Appeals. But with respect to the criminal aspect, it is under Rule 65 before the Supreme Court, petition for certiorari. That is the one that was asked, sir. But with respect to your question, it is immediately executory, sir.
Will an appeal stop the decision from being executory?
The general rule, sir, is that the appeal stays. No, that's the general rule with respect to judgment decisions. But with respect to the ombudsman, I believe, sir, it is immediately executory unless the Court of Appeals in Administrative or the Supreme Court issues a TRO.
Issues at TRO. Again, I will not be conspicuously repetitive of such question I asked from other applicants to several applicants whether there are perceived conflict between the functions of the Ombudsman and the Court of Appeals in the matter of the issuance of TRO. Are there?
I guess none, sir. I guess there's no conflict. The ombudsman, I believe, cannot issue TRO, sir.
All right. In case the penalty is suspension removal and the respondent wins the such appeal, will it be considered as having been under preventive suspension? And one should be paid the salary and such other emoluments?
No, sir, because preventive suspension under the law is not considered as penalty. It is a preventive measure in order that the officer concerned who has been put or placed under preventive suspension cannot influence while in office the other witnesses or tamper with records. So if ever that government official wins the case, he should not be entitled for emolument or compensation with respect to the preventive suspension because, as I said, it's not part of the penalty, sir.
You're also applying as the position for Associate Justice of the Court of Appeals?
Yes, sir, that's correct.
Judge, what is the doctrine of unconstitutional uncertainty?
The doctrine of constitutional uncertainty. This is just a guess, sir. Unconstitutional certainty. So there is a doubt, sir, whether a law or a statute is constitutional or not. I'm not sure. I'm not sure. I haven't encountered that doctrine, sir.
All right. Kindly explain the difference between the right to speedy disposition of a case and right to speedy trial.
Yes, sir. So right to speedy trial as against speedy
No, first,
disposition of the
speedy.
case, sir. So speedy disposition
Yes.
of the case, sir, pertains, I guess, I believe, pertains to mechanical act of disposing the case in the swiftest manner. So it doesn't concern itself with the quality of the decision. The paramount consideration is to just immediately dispose of the cases. It pertains to the court, sir, in order to lower the docket. But the speedy trial is something that is more required. Speedy trial, sir. Speedy trial is per se, to be bookish or textual about it, is that compliance with the mandated circular of the Supreme Court with respect to the Speedy Trial Act, sir, complying with the dates mandated by said circular in resolving motions, issuing decisions. That's the Speedy Trial Act. So normally, sir, Speedy Trial Act pertains to the both civil and criminal cases that comply with the mandate of the circular in order the time within which to resolve the pending motions or decisions.
And how would you differentiate conclusiveness of judgment and bar by prior judgment?
Yes, sir. There are the two kinds. The bar by prior judgment. There are in bar by prior judgment, a decision that has already become final, sir. It is equivalent to res adjudicata. A decision that has already become final is binding on the parties in such a way that the other party or the other party can no longer file another case of the same involving the same issues, subject matter, or parties. While with respect to conclusiveness of judgment, there is a case already final, and the decision itself is binding to both parties. So it does not presuppose the fact that there is another case to be filed with respect to conclusiveness of judgment. Unlike in bar by prior judgment, there is supposedly another case being filed. And that under that principle, bar by prior judgment, the principle of res adjudicata comes in, that the court, motu proprio, on its own, can immediately dismiss the case because of bar by prior judgment.
All right. When can a party change her theory on appeal? What's the rule?
The general rule is that all issues not raised before the trial court can no longer be raised before the appellate court. So that's the general rule, sir. So the exception is that I believe if there is a newly discovered evidence filed in accordance with Rule 53 of the Rules of Court before the appellate court, so that issue may still be raised before the appellate court, before the Court of Appeals, sir.
All right, my last question, Judge. What do you think is your biggest weakness that might actually be a strength?
Okay. I believe, sir, the word weakness is something that already acquired permanency. Weakness. So a person admits this is the weakness. There is not so much to be done about it. What I'm saying, sir, is that I want to put the perspective on the word failures, but not weaknesses or challenges instead of weaknesses. Because failures are deemed as temporary, while in a weakness, it connotes something permanent that may not be remedied. So, but answering your question, weakness, I cannot think, sir, of a weakness, but challenges. There are a lot. I had a lot of challenges, but weakness, I cannot think of a concrete weakness because, as I said, I face the challenges. I don't want to become them as weakness in such a way that I cannot do something about it. That's just my personal view, sir, of course.
So you don't have a weakness?
In a sense, sir, but I have many challenges. Weakness, I just not inclined to use the word weakness, but challenges. Because weakness, sir, is something that we admit that we cannot do something about it. That's my perception, sir, of the word weakness. Weakness is something that a person already accepts that he cannot do something about it. That's why a person accepts that as a weakness. But for me, as I said, I want to use the word challenges or even failures because they are just temporary.
That is your strength.
Yes, sir. Yes, sir. Because, yeah, the answer to your question, that is my strength. I don't want to categorize something as weakness, but challenges that are open to opportunities, sir. That's why I do something about it. I rise from the challenges.
Okay, thank you, Judge Hercules or Atlas, because you're strong. And thank you for your time. And
Thank you
good luck.
very much, sir. Thank you very much, sir.
Thank you. Good luck.
Thank you, sir.
Thank you very much, Your Honor. Judge Ilaw.
I'm done.
The last
Tawa na tawa dyan. All right, thank you. I'm
Thank
done.
you, sir.
Thank you, Judge.
Good afternoon, Judge.
Good afternoon po, sir. Good afternoon, Justice.
There are two of you applying from Mariveles.
That's correct, sir.
No,
We've been together.
Interviewed today, or both of you today.
Yes, sir.
Coincidence siguro.
Yes, sir. Because our surname, he is Q, I am S.
Oh.
So we were...
You're not from Batangas?
Bataan,
Silva?
sir. Bataan. Batangas, yes, sir. My grandparents are from Lipa and Tanawan.
So many
Yes, sir.
Silvas
Silva.
there. So
Lipa
you
and
own
Tanawan.
the bus lines?
Yes, sir.
Are you on that?
No, sir. I thought your question is that do you take a bus line? As I said, yes, sir. Because even going to Bataan, I just take bus, sir.
Because in Lipa, they have a bus line.
Yes, sir. We don't own that, sir.
Transportation company before.
We belong to the Poor Silva, sir.
Okay. I'll begin with what you have written. Just a few only. You wrote that your answer. We'll assume that this was because the question was about President Trump. Let us consider that it was our president, and we will discuss this in the context of the Philippine Constitution. Now, if it is in the in the context of the Philippine Constitution, will you have the same views that the media violated the Constitution, that the president his constitutional right to freedom of expression was violated?
Yes, sir. I still maintain the same answer.
Yes.
Yes, sir. I
maintain that?
maintain the same answer.
What did the media violate? Did
They
they prevent him from speaking or from continuing his speech? He was allowed to continue his speech, right?
Yes, sir. That's
Or
correct.
why do you say that his freedom of speech was violated?
I maintain, sir, that
Because di ba
Um,
private, there are only few government networks. There are many private networks. Di ba they have the discretion to choose whether to choose what events that they will cover?
yes, sir. I
So
submit to that.
if they have such discretion, why do you say that they violated the constitutional right of the president, the freedom of expression?
I will change my answer, sir.
You will change your answer.
Yeah, because if that is the only media at that time broadcasting the speech of the president,
You're now qualifying.
yes, sir, I am qualifying because it
You're
happened in the States, sir. CNN.
Yes, but there are
Yes.
so many, many private networks there.
Yes, sir. If there are
Oh.
many networks, particularly, let's say
Only
there is a
one.
government network.
Oh, only one stopped airing his speech.
Now I have to change my answer, sir. If the particularly private broadcasting firm cut off the speech of the president, it does not violate the freedom of expression because there are still other broadcasts, particularly the government broadcasting company, that can air the speech of the president.
Okay. What are the essential elements of the freedom of speech?
Yes, sir. The freedom of speech the freedom of speech has three essential elements. The first is the freedom from self-restraint.
I have
two
only.
two, sir, because the other one is almost the same, sir. Freedom from prior restraint.
Yes.
And also, which is also another one that can be joined in that is the freedom from censorship. And the other one, sir, the next is that freedom from subsequent punishment.
Yes, okay. Now we'll go to number 5. The decision of the courts interpreting the law. What do you make of them? What is their nature under our system of government? How do you categorize them? Court decisions. They're covered under the civil code of the Philippines.
Civil code, sir. The decisions of the court form part of the law of the land, as what I say. Remember, sir. Particularly the Supreme Court.
Remember. Oh, that's
Yes,
what
sir.
you remember. Okay. So that is tantamount to judicial legislation because they form part of the law of the land.
The jurisprudence, sir. They form part of the law of the land.
Jurisprudence? What is?
Yes, the decisions of the Supreme Court,
you said
sir.
the Article 8, diba? You were referring to Article 8.
Yes, sir.
Yes. Oh, now that was your basis. You have also jurisprudential basis saying that they form part of the law of the land. That is judicial legislation, diba?
Yeah, but it's provided, sir.
It is provided
that decisions of it pertains to the Supreme Court, sir. That decisions of the court or the Supreme Court form part of the law of the land.
That's what you remember.
That's what I remember, sir.
Oh, I see. Oh, uh, I will read to you Article 8.
Yes, sir.
Judicial decisions applying or interpreting the laws or the Constitution shall form a part. You're referring to this?
Yes, sir.
Shall form a part of the legal system of the Philippines, not the law of the land.
Okay. Legal system, sir. I'm sorry.
You're referring to, we have no more time, you were referring to what? When you were talking about law of the land, forming, becoming a part of the law of the land. What were you thinking? What were you referring to?
Oh, I'm referring to the decisions of the Supreme Court because we tell judges if we don't have a particular law on the matter, on the issue,
That's
before the
another
case.
That's another
Yeah,
article.
we
Anyway, I
go
will remind you, Judge, that's another article. Because of the obscurity, insufficiency of the law. I'm not referring to that. So I will
Sorry,
just
sir.
remind you that international laws, when they are, Philippines is a signatory, they form part of the law of the land. Siguro you're tired, confused ka, Judge.
Yes, sir. So is that, sir, the doctrine of transformation?
Yes, so that's, so now you remember, you now know the difference.
Yes, sir.
Judicial decisions do not form part of the law of the land. It's
Yes, sir.
only our legislature.
Yes, sir. Thank you, sir. I now
What
know.
do you know of executive, so-called executive legislation? Is there such a thing?
Yes, sir. Executive branch of government issuing, let's say, administrative orders, resolutions that may
Executive orders, right?
administrative orders,
IRR.
IRR,
Okay.
that may be beyond what is stated in the law. So beyond.
Yes, they can do
Yes,
that.
sir. They are not, sir, because
they are not.
the IRR,
They cannot do it.
they cannot do it, sir.
They
They
cannot
must
do it. They must comply with the law.
comply with the law.
So it's not executive legislation.
Yes, sir.
Because I asked you earlier about executive legislation, and you said, and you enumerated them. What are they? Those enumerations, are they executive legislations? They are not the legislation.
No, sir.
No. Okay, you're changing your answer now.
Yes, sir.
I see. What did you were? Oh, this is easy for you. You work under Tony Omar Viola.
Bihilya, sir.
Bihilya.
Yes, sir.
Bihilya. Sorry,
He was my boss.
Omar Viola is a judge nga pala.
Yes, sir. He's the judge of Angeles City.
Omar Bihilya.
Omar Bihilya, sir.
Yes.
Yes,
Okay.
he was my boss.
You can easily answer this. A purchaser at a public auction conducted because of a foreclosure mortgage, asked for a writ of execution. And what is the nature of that writ of execution?
Yes, sir. It's already ministerial. The
Yes,
issuance of writ of execution or writ of possession.
Yes.
Writ of possession, sir.
It's ministerial, di ba?
Yes, sir.
And it can be, you can file a petition, and
Ex parte.
the proceeding is ex parte, right?
Yes, sir. That's correct.
Kaya nyo. When is the court not allowed to implement, or the sheriff allowed to implement the writ of possession? Very easy for you. You came from the bank.
Yes, sir. Writ of possession in the first place cannot be granted, sir, if the 1-year redemption period, as far as, let's say,
suppose the redemption period has expired.
Yes, sir. It cannot be implemented, sir, if the other person, not the mortgagor, is in possession of the property, sir. Because writ of possession connotes that the person in possession of the property is still the previous mortgagor. But if it's another person, let's say a tenant of that owner, the writ of possession is not viable. The highest bidder or the new owner must file ejectment case.
That's your interpretation. So he is not claiming rights under the obligor.
Yes,
The
sir. The
tenant.
tenant.
Di ba when in the writ of possession, when you issue the writ, you're directing the sheriff to remove the one
Occupant.
in possession, and also the obligor and all those persons claiming
Persons
rights.
deriving rights under him.
Correct, right?
Yes,
Oh.
sir. But as I
Oh.
said, sir, if another person not deriving rights under him, let's say there is a tenant, particularly the tenant was able to
So,
annotate
because
his or her claim on the title.
You called him tenant, so he must be a legitimate tenant.
Yes, sir. Legitimate tenant.
So
There's a
he's
contract.
claiming rights derived from his relationship with the obligor, right?
As far as I recall, sir, because I
Anyway,
handled that.
Yes, I know. That's why I asked you that.
Yes, sir. I handled that.
Yes.
Tenant, even the jurisdiction, sir, we file it before the MTC.
Yes,
The one
correct,
that has the jurisdiction for ejectment.
Correct. Oh.
Yes, sir. Let's say, if not a tenant, a relative of the previous owner, writ of possession is valid, can be enforced.
Categorize the two. A relative, a tenant.
Relatives,
what do you categorize them? How do
all
you
persons
categorize
claiming
them?
rights under him, sir.
Oh.
All persons claiming rights under the
Oh.
previous owner.
The sheriff cannot implement, or the judge cannot insist on its implementation when the possessor is in possession of the property adverse even to the obligor. Adverse.
Yes, sir.
to the obligor.
Adverse.
You
Yes, sir.
remember?
Yes, sir.
Oh,
The word
kaya mo
adverse.
yan. Because you work with the bank. Kaya mo. Oh. Now, you answered earlier, nuisance. Oh, how do you abate a private nuisance?
The nuisance per se, sir, may be abated by by
No, I'm not a private nuisance. Abatement of private nuisance. What are the requisites? Anyway, you're not teaching that, ano?
Yes, sir. It causes
Okay,
Jude.
Abatement. What is abatement? Extrajudicial abatement of a nuisance. Can there be an extrajudicial abatement of a nuisance?
Yes, sir. The LGU is exercising that.
What are the requirements?
Normally, if
But
it
even by a private party, not even the LGU, not only the LGU.
In most cases, abatement, sir.
What are the requisites when you can?
I cannot enumerate the requisites, sir,
okay
for
lang. Okay lang.
abatement.
Okay
It's
lang.
more on civil law.
Okay. You're a wide reader. I noticed that. Very good. Well, last week, have you heard the case of Tansin versus Tanvir? No. It's the
No, sir.
US Supreme Court decision wherein the Supreme Court dismissed the petition before it because it became academic. But the one who filed the petition complained that because of the directive of President Trump, limiting or restricting their travel because they are Muslims. Their such imposition by the officers unduly burdened their right
Right
as a
to travel.
Muslim. No, right as a Muslim. The religious right. Religious right. Now, it was dismissed, but it was opined that the affected persons can file a case against the officers who implemented that. In the same decision, it stated that the officers can invoke qualified immunity. What is qualified immunity?
I haven't read that decision, sir.
No, we have that in the Philippines. The
Qualified.
Lima versus President Duterte. Qualified immunity. Hindi mo alam?
I wasn't able to read that, sir.
Okay, I know baka hindi pa nabasa yung US decision.
Yes, sir.
But yung De Lima versus President Rodrigo on immunity, dapat alam mo. You have
Yes, sir.
not read it?
I wasn't able to read them, sir. What I read is yung mga SAPLA case,
ay siya o mga ano yun, mga SAPLA is warrantless search.
Yes, sir.
Sige,
And,
I will not ask you
Saluday
about
case.
them. Saluday. The
Yes,
Oakland.
Oakland, yes, sir. So the foreign, the Irish national who smoked marijuana at the airport, Lawag.
It was the airport in Lawag, the
Yes, sir.
place of the Chief Justice. But I will not ask you on that. Because
He was
you know
even the
that.
one who penned the decision, sir, Chief Justice, in the
Yes.
case of Oakland.
Yes.
Yes, sir.
But I will ask you another one, close to your heart also.
Okay, thank you, sir.
Sige. Okay, this involves employees of the central bank. So alam
Bangko
na alam
Sentral,
mo to.
sir.
Yes, Bangko Sentral. The employees there committed some discrepancies because it affected the banking operations of two banks. One bank complained. He said that in their you are aware of the central bank clearinghouse, right?
Yes, sir. The exchanges of the checks between and among banks.
It was discovered that there were the interbank reconciliation and there were the discrepancies committed. Now the bank complained. Can the bank, the private bank, can the private bank file a case against the central bank?
Sir, I read a case, a recent case about that.
That's why I'm asking you. Kayang-kaya mo.
I believe that, sir, in that decision, the Supreme Court said that the central bank cannot be sued because the employees committed the criminal act not in the performance of their obligation, of their assigned task. The Supreme Court said that that since the employees perform or committed the criminal acts not in the performance of their assigned task to them by the Bangko Sentral, only the employees can be charged, sir, but not the Bangko Sentral.
Not the Bangko Sentral. What
Yes,
are
sir.
the other reasons?
The other reason, sir, is that they are not considered as agents of the
How about the
Bangko
central
Sentral.
bank itself? Is Bangko Sentral? How about the Bangko Sentral?
The Bangko Sentral, sir, is immune from suit on that aspect because it is performing in accordance with the decision, sir. It's performing governmental function. Clearing is a governmental function, and therefore, Bangko Sentral is immune from suit on that aspect.
I see. You do not qualify? You want to qualify?
There's a qualification in that case.
Yes.
If the
Yes.
Bangko
What is the-
Sentral gave
Yes.
a some sort of authorization or permission or knowingly or the Bangko Sentral knows and consented to the illegal acts of the employees.
Even if it is performing only purely governmental function, is it liable? No, your answer should have been, it depends whether the central bank is performing government or proprietary function. Yes.
But that one is not proprietary, sir. It's governmental function.
That's the reason why I asked you to qualify.
Yes, sir. That's correct. If the Bangko Sentral is performing proprietary, it can be sued.
Proprietary. Oh,
Yes, sir.
yes. Oh, in that case, it said on the assumption that the CBC is performing proprietary function, can it be held liable for the acts of its employees? Anyway,
Yes,
you
sir.
answered that earlier.
Yes, sir.
Kaya lang, I wanted you to qualify first the central bank, whether it's performing proprietary function or purely governmental function. Oh. Now, what else? I will go to. Wala na, may type pa ba? What is the Immutability Doctrine?
It's that doctrine states that once a judgment is already final, it could no longer be altered nor changed.
Okay.
Except for some exceptions.
Yes.
Non-proton.
Okay. Give me 5. Give me the 5 exceptions.
One is non-proton, or let the record speak the truth.
Yes.
When there is a typographical error.
Yeah. Okay.
Okay. And then when I cannot remember the other three, sir.
I will help you. Apo Fruits versus Land Bank of the Philippines. Bangko rin yan. Kaya tinatanong kita.
Yes, sir.
There are five exceptions enumerated in Apo Fruits versus Land Bank of the Philippines.
Yes, sir.
Do you remember? Okay. The third is void judgment.
Void judgment.
Yeah. The
Yes,
fourth are circumstances which there are circumstances which transpire after the finality, rendering its execution unjust and inequitable.
Yes, sir.
And the fifth, when there are facts and circumstances rendering the execution impossible. Okay.
Yes, sir. Rendering possible.
Yes.
Thank you, sir, for that. I
Anyway,
forgot the three.
You teach that You teach remedial law. Kaya mo yan, di ba?
Yeah, but at present, I'm teaching commercial law, sir. But
commercial law.
Yeah, present.
But you're going to be a judge. You are applying in the Sindigan Bayan and
Yes, sir.
also the Court of Appeals sa Sindigan Bayan. Ang ba tatanong ko sa'yo?
Yes, sir. If you kindly, you can ask the case of Alfredo Non, sir. A recent case.
I'm not going to ask about that.
The Republic Act 10660.
Most of the cases in the Court of Appeals concern the procurement law. The general mode of procurement is public bidding.
Yes, sir. Public bidding.
Can you give me some example? Exception. Sorry.
Number one, sir, is in case of emergency that necessitates the delivery of the goods, sir. Just like, let's say, this COVID.
Yes.
Yes, sir.
They still comply with the. They still bid. May bidding
yes,
pa rin.
Sir. Yes, sir.
No. What are the requirements? What are the general exceptions? Well, I'll name them: limited source bidding, direct contracting, repeat order, shopping, negotiated procurement, like that. So can you give me examples or samples negotiated procurement? There are 9 in the law, but give me at least 3.
Negotiated procurement, sir.
Yes.
So I believe it's just
Marami. There are 9. I'm asking for only 3.
I wasn't able to read, sir,
Hindi ba?
the bidding.
One is failure of public bidding for the second time.
Okay.
Number 1. Second is imminent danger to life or property during state of calamity. Takeover contracts. Marami yun, but
Yes, sir.
you just review them. We're running out of time,
Yes,
Judge.
sir. Yes, sir.
So that will be all, Judge. Thank you very
Opo.
much.
Thank you very much, Justice.
Okay.
Thank you po. Okay.
Thank you very
Permission
much,
to
Your
log
Honor. Justice Mendoza. That brings to a conclusion the public panel interview of Honorable Judge Emmanuel A. Silva. Judge Silva, thank you very much, and
Thank
we
you,
wish
ma'am.
you the best of luck.
Thank you. Permission to log out.
Attorney Leia. Si Judge Reyes is
Yes, Attorney Ann, admitting po.
Nandiyan.
Judge Solis Reyes. Judge Reyes. She's here na po, Attorney Ann. Judge Solis Reyes, can you hear me po? Yes, Judge Reyes, can you hear me loud and clear? Judge Reyes?
I'll call her mobile po, Attorney Leia.
Thank you, Miss April. Kindly ask her to connect her audio.
Yes po.
Thank you. Judge Reyes?
Low signal po siya.
Miss April, can we also ask Judge Reyes to turn down the volume of her secondary device so there won't be any feedback? Thank you, Miss April.
Yes po.
Attorney Leia, okay na?
Setting up po her devices, Attorney Ann. You can't hear us pa rin po. Good afternoon, Judge Reyes.
Good afternoon. Good afternoon po.
Yes, can you hear me loud and clear, Judge?
Yes, I can hear you.
Your internet bandwidth is low, Judge. Do you have your data so we can use it instead?
I'm sorry.
Are you using Wi-Fi po, Judge? Are you connected to your Wi-Fi or data?
I'm connected to our internet.
Wi-Fi.
No, not data. Wi-Fi, internet.
Okay. So your internet bandwidth is low, Judge. Dennis, do you see her main profile, main device? Judge, can we switch to your secondary device? Dennis, can we put on spotlight mode, Judge? This is your secondary device, Judge. Can you turn to your right po? Right. Are you using a mobile device po as your secondary device?
No, it's also a laptop.
Can you turn to your secondary device instead because your primary device is not working? Can you pakitilt lang po ng screen upwards so we can view you can see your face. Upwards po, pataas po. Or pababa if that's the case, if you're using an iPad. Yan. Pwede po niyong ilayo from a few inches po from you. So, hindi po masyadong close up. Paangat lang po, Judge, para makita yung mukha ninyo. Kasi right now, you're out of focus.
I cannot hear you. I'm sorry.
Paangat lang po nung screen because right now you're out of focus. Angat lang po natin.
Angat?
Yes po. Kasi there, Judge. We can see you now. Okay na po. But can you hear me now, Judge?
Okay na?
Yes, Judge. Can you hear me po? Can you hear
Yes,
me?
yes.
Okay, Judge. Attorney Ann?
Your Honors, the
Okay na
next
po.
candidate to be interviewed is Honorable Judge Jocelyn A. Solis Reyes, presiding judge of the Regional Trial Court, Branch 221, Quezon City. She is an aspirant for the position of Associate Justice of the Court.
I'm sorry. I cannot hear you. I'm sorry.
Judge, do you have earphones I think it's better if you use earphones. Judge. Because your main device, if you use your main device, your internet bandwidth is low. So, Dennis, can we put on spotlight mode the main device of Judge Reyes?
Can I ask someone to,
You may ask somebody from your office to assist you po.
because I cannot hear you clearly, to assist me, can I ask someone?
Yes, Judge. Yes,
Okay,
Judge. Opo.
okay. For a while.
Your Honors, sorry po, we'll just fix because Judge Reyes's internet connection is fluctuating. That's why we asked her to use her secondary device instead.
Pwedeng pakilakas mo lang ang boses. Paano ba yun? Ha? Parang pakilakas lang. Oo, yung boses. Hindi ko marinig. Oo, taas mo. Taas mo yung
Sir?
taas mo yung ayun ang maximum.
Sir, mahina po yung internet signal ninyo. So, hindi po nare-recognize yung main device. Dun po sa secondary. Okay na po? Can you hear me, Judge?
Maximum na daw. Attorney.
Yes, Judge, but can you hear me po? We can hear you loud and clear from our end, but can you hear me, Judge? Hindi pa rin.
Wala, dapat pala meron na. Sige, okay, thank you.
Hindi pa rin.
Off mo na lang siya.
Can you hear me now, Judge?
Off mo na lang. Ito, ayan ang ano, oh. Ayan. Off mo na lang. Sa gitna. Sige, iyak na lang. Oh, okay na yun, okay na. No, yung okay na.
Judge Reyes, can you hear me? I think you have to turn down the volume of your secondary device po because to prevent feedback. Otherwise, feedback po tayo. Don't turn it off. Just turn down the volume of your secondary device. If you're using a laptop as secondary device, you have to turn down the volume, Judge. Okay na po. Can you hear me now, Judge?
Yes.
Hindi pa po siya nakababa yung volume. May feedback pa rin po. Turn down po, don't turn off. Turn down, hinaan lang po. Now, Judge, can you speak po if may feedback pa? Judge?
Yes.
Can you ask your staff again po? I will try to instruct him to lower down the volume of your secondary device. Your assistant po, Judge. Judge. Secondary device, Dennis, please. Ayaw talaga sa main.
I do not know what saying about the secondary device. These are two. Which one is the first?
Yes.
The secondary and the primary device.
The secondary device is the device on your left or right side. The one in front of you is your main device, the laptop or desktop that you're using that's in front of you.
Okay.
So this is your secondary device. It's now on spotlight mode. Can you view it now, Judge? Do you see it po? There.
Thank you.
Can you hear me now, Judge?
Yes, attorney.
Okay. Can you speak po, Judge, so we'll know if there's feedback? Judge, your internet bandwidth is low. Judge, turn down the volume of your secondary device po because there's still feedback po. Hinaan lang po natin. Kasi may echo and feedback po if natin hinaan.
Hindi ako marunong.
Can you ask your assistant again po to do it for you? Sir, dun po, hindi po dyan, that is the main device. Yung isa pong device na nasa gilid ni Judge, yun po yung hihinaan natin ng volume. Yung isa po. Ito pong device na ito. Laptop po ba yan or cellphone or desktop? Hihinaan lang po, hindi po i-off. Now, Judge, I will send a request to unmute your audio now. Dennis, please. Kindly press unmute, Judge. There is an icon on the lower left portion of your screen that says mute, unmute. Paki-unmute po. There. Can you speak now, Judge?
Okay,
Judge. Hindi po nahinaan again yung secondary device. Sir, hindi po yan yung isa po, yung nasa gilid po na device, not that one. That is the primary. Yung isa po, sir, sir, that is the primary device. Yung isa po na device na ginagamit, kasi dalawa po yan, yung isa pong device. Yan. Okay na po, Judge? Can you try, magsalita po kayo, Judge, so we'll know if there's feedback. Judge?
Okay na. Attorney?
Yes, Judge, can we just ask you to turn off your primary device and we'll just use your secondary device po? Turn off your main device, the one that's in front of you. If that is a laptop, just turn it off na lang po and we'll just use your secondary device. There won't be any backup kasi anyway, your internet is low naman po eh.
Attorney, okay na?
Yan, that's better po, Judge. Okay po. Sorry, Your Honors. Attorney Ann. Thank you, Judge.
Good afternoon, Honorable Judge Reyes. Before your interview, may we first request Attorney Edgar Aricheta to administer your oath.
Attorney, I can hear you.
Attorney Leah, she can't hear us now.
Judge, does anybody there in your office have earphones that you can use? Because it won't be, it seems that there's something wrong with the audio of your device. So you'll be needing earphones po. Meron po ba? Does anybody from your staff have earphones? So, yun na lang po yung gamitin natin.
Earphones?
Yes, Judge.
Earphones? Yes, Judge. Wala po yata eh.
Judge, ito pong, ano po yung ginagamit nyo? Laptop and cellphone or laptop and desktop?
Laptop pareho.
Judge, yung isa pong laptop, i-turn off na po natin. Yun pong nasa harap ninyo.
I-turn off ko na?
Apo, isa na lang po yung gamitin natin.
Yung secondary, i-turn off ko na?
Yung primary po ang i-turn off ninyo.
Yung primary?
Yes po. Shut down nyo na po, Judge.
Itong nakaharap sa akin.
Yes, Judge. Yan pong nakaharap sa inyo. Now, Judge, okay na po? There. So, we are now using your secondary device. Can you hear me now po, Judge? Pwede nyo na pong lakasan yung volume kasi I asked you kanina to turn down the volume. Ngayon, pakilakasan na po ng volume ng device, ng isang laptop. Meron pong icon, lower right portion of your screen, na parang megaphone. Just click it. Okay na po, Judge?
Okay na?
There. Can you hear me now, Judge?
Yes, Attorney.
Okay, thank you. Attorney Ann. Attorney Ann?
Okay na, Attorney Leah?
Yes, Attorney Ann. Papa. Yes, Attorney Ann.
Good afternoon again, Honorable Judge Reyes. Our ex-officio secretary and the Supreme Court Clerk of Court, Attorney Edgar Aricheta, will first administer your oath before your interview.
Judge Solis Reyes, good afternoon po. Judge,
Good afternoon
can you hear
po,
me?
sir.
Good afternoon. Please raise your right hand so that I can administer the oath. Judge, do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview by the Judicial and Bar Council?
I do.
So help you God. Thank you, Judge.
Thank you po.
The first to interview you will be the Honorable Judge Franklin J. De Monteverde.
Okay, thank you, Attorney Ed.
Good afternoon po, sir.
Yeah, good afternoon, Judge Solis Reyes. I'll just
Good
call you
afternoon.
Judge Reyes, para maiksi.
Apo, thank you po. Yes po.
If I remember correctly, you were interviewed by us last year,
No, sir. No, Your
2019.
Honor.
You did not apply.
I did not apply, Your Honor.
Okay. But for this year, you applied for a seat in either of the Court of Appeals or Sandigan Bayan.
My last application was in 2016, Your Honor, and I just applied now, Your Honor.
Now, okay. Judge Reyes, are you the one who handled the Maguindanao massacre case?
Yes, Your Honor.
How was your experience handling it?
I think it was, well, until now, I'm still handling it, Your Honor. But
Until now, I thought you rendered a decision already.
yes, but it was just a partial consolidated decision, Your Honor.
Okay. So, what did you gain from handling it?
It's a life-changing experience, Your Honor.
Why?
First and foremost, I felt that I lose my privacy.
Okay. You became famous for that and popular.
I don't know. Not really famous, Your Honor, but
Popular, probably.
I have my guards, Your Honor. Guards
Yes,
were
because
assigned to me.
I understand that there were death threats hurled your way, so bodyguards were securing your securing your safety, di ba?
Before, Your Honor, there was, I don't know. They are not telling me regarding the security matters, Your Honor.
Okay, I'm interested because in this case, because one of the victims was a lady lawyer, a small lady lawyer who appeared before my court here in Negros Occidental a week before the massacre. She is known to me. She was known to me, rather. And the other one, well, some acquaintances merely. Okay, going over your PDS, you listed 3 names. You said that they are your children, but looking at their ages, they are almost the same as you are. You are 60 years old, and one child was 60, the other is 54, and the youngest is 52. Please explain.
Your Honor, I don't know how to use, Your Honor, can I just use your phones?
Okay. For as long as we can communicate to each other.
Your Honor.
Okay, can you hear me, Judge Reyes? I can hear you, but can you hear me?
Yes, Your Honor.
I cannot hear you. Your voice too far away. Seems that you are you. Okay.
Can you hear
Try
me,
talking.
Your Honor?
Malayo rin. Malayo.
Malayo po, malayo.
Malayo yung boses mo. Hindi ko maano.
Judge, if I may.
Sige.
Your Honor, Judge Solis, there is a microphone attached to the wire of your earphones. Ilalapit nyo lang po. There is.
Hello po.
Yes, Judge.
Can you hear me now?
Na mahina po. Judge, Dennis, can you put me on spotlight mode, please? Judge, there is a microphone attached to the wire of your earphones. Do you see it po? This one?
Opo.
Pakilapit po sa bibig.
Ito po.
Yan. Thank you, Judge.
Can
Thank
you hear
po,
me
Your
now?
Honor. Thank you, Your Honor, Judge
I
Simonte.
can hear you now.
Opo. Thank you po. Thank you.
But can you
Thank
hear
you.
me?
I can hear you po.
Okay, sige.
Thank you po.
Now, where was I? About the names of your three children, aged about the same age as you are.
Yes, Your Honor.
Who are they? Who are they?
They are my stepchildren, Your Honor.
Stepchildren.
Yes, they are the children of my husband, but not my children.
From another.
From another marriage, Your Honor.
The first wife died already.
Yes, when I met him, the first wife was already dead.
Okay. How old is your husband now?
He has just turned 81, Your Honor.
Mm-hmm. And according to your salin, he is in the United States.
Right now, he is in the United States, Your Honor.
Why? Is he an American citizen?
He is, Your Honor. A dual citizen, Your Honor.
Okay. How about the children? Your stepchildren?
They are American citizens, Your Honor.
Okay. How long have you been married, Judge Reyes?
25 years, Your Honor.
Okay. Now, you are the presiding judge of the RTC Branch 221 in Quezon City. Am I correct?
Yes, correct, Your Honor.
And how long have you been there?
Almost 16 years, Your Honor. Come December 29, on record, Your Honor.
And what is your caseload now?
It's more than 100, Your Honor. I think, if I'm not mistaken, Your Honor, because when my court, Branch 221, was designated as a special court to handle the Maguindanao massacre cases,
Okay.
I was not raffled any case.
Mm-hmm. Okay. Now, for how long have you been with the judiciary?
19 years, Your Honor.
Including your stint at the MTCC?
Yes, Your Honor.
How about in the government? For how long have you been there? Have you been working for the government?
Since 1982, October, Your Honor, with a gap of 1 year only.
Okay. But you passed the bar in 1988.
Yes, Your Honor.
That was on your second attempt.
Yes, Your Honor.
Okay. Now, just would like to inform you that the JBC, under the JBC rules, those who passed the bar exams on their first try are given priority to nominations. But this does not mean that second timers, third timers shall be set aside. For us,
I understand, Your Honor.
This can be compensated if you have other credentials, other awards, other citations that you have earned during your school years and also during your professional years. So can you cite some credentials and awards that you have received? Can you hear me, Judge?
Recognition. Yes, Your Honor. Recognition.
Yeah.
Were you referring to recognition, Your Honor?
Any recognition, appreciation, awards, whatever, or credential. Do you have any master's degree?
I don't have a master's degree, Your Honor.
What other degrees do you have?
Well, except for my pre-law, the journalism, I don't have any other degrees, Your Honor. I was merely recognized by when the Maguindanao massacre cases were raffled to me. I was recognized by one of it's an association of media people.
Okay.
and I was given a plaque of recognition, Your Honor.
Mhm.
And I was also recognized by my sorority in UST, at
Mhm.
UST. And after the promulgation of judgment, Your Honor, in December of 2019, several months after that, the local government of Quezon City uh, issued a resolution recognizing me, Your Honor.
Some more? Wala na.
Wala na po, Your Honor.
Okay, sige, Judge Reyes. Now let's go to current events, no? Some of the country's property developers have joined a movement that push for amendments to the Republic Act 9646 or the Real Estate Service Act of 2009. They particularly denounced Section 14 of that law for what they call as discriminatory scholastic requirements, referring to both the requirements of BS in Real Estate Management degree for brokers and the 2-year college for salespersons. They say that the law has deprived developers of a provincial network or marketers because of the low number of licensed brokers. Your take on this, Judge?
Actually, Your Honor, I have not read that particular law on the real
Okay.
estate, Your Honor.
Okay. So let's go instead to the amendments to the rules on civil procedure. Give us two kinds of defenses in an answer and define. Two kinds of
Affirmative
defenses
defenses, Your Honor.
in an
Affirmative
answer.
defense.
One, the
Uh,
what is negative defense, by the way?
Negative defense, Your Honor.
Uh-huh.
A negative defense, Your Honor. It's a denial, Your Honor, on the allegations of the plaintiff.
What kind of denial?
Unexpressed denial, Your Honor, on the in the complaint complaint of the plaintiff.
Okay, what's the other defense?
The affirmative, Your Honor.
Affirmative, and what is it?
The defendant therein, Your Honor, invokes something other than the outside of the allegation of the plaintiff.
And while doing that, does he admit the material allegations in the pleading?
Not necessarily, Your Honor.
Not necessarily. Now, in the old rule, the affirmative defenses were enumerated as the statute of frauds, estoppel, former recovery, discharge in bankruptcy, and any other matter by way of confession and avoidance. Can you cite the included grounds for affirmative defenses in the new rules?
Payment, Your Honor.
Hmm?
Payment, prescription.
Okay. What are the others?
Res judicata.
Mm-hmm.
Litis pendentia, Your Honor.
Mm-hmm. There are only three. The last one. Yung number one mo.
Prescription, Your Honor.
Hindi. Jurisdiction over the matter.
Oh, I'm sorry. I stand corrected.
Now, after the denial of the motion for reconsideration, denying his affirmative defenses, the said party filed a petition for certiorari, prohibition, or mandamus. comment on the motion for reconsideration and rule on the petition.
The well, the motion for reconsideration should be outrightly dismissed, Your Honor.
Why?
It
For
should
what
not
reason?
be. It should not be allowed, Your Honor. Although his affirmative defense, Your Honor, the denial of the affirmative defense should be raised by the defendant on appeal. It may be raised as one of the errors on appeal, Your Honor. But
So the filing of a motion for reconsideration is prohibited, as well as the petition for filing of the petition for certiorari, prohibition, or mandamus. Correct.
I think so, Your Honor. But yes, Your Honor, unless there is grave abuse of discretion, Your Honor, in which case certiorari may be filed. But Your Honor, it's I think instead of filing those action and the motion, the party instead, or the defendant instead, must file should proceed with the pretrial, because he has already filed his or her answer to the complaint.
Anyway, review further, Judge, Section 12E of Rule 8, which prohibits the filing of a motion for reconsideration and petition for certiorari and prohibition or mandamus.
Yes, Your Honor.
Okay. Now, a third or fourth party complaint was filed with leave of court, but was denied. On what grounds can it be denied?
That the party complaint has no interest over the subject matter of the case, Your Honor.
No, there are three, Judge.
I was not able. That's what I know, Your Honor. That's what I know.
Amendments ito, Judge, sa Code of Civil Procedure.
Yes, Your Honor.
Anyway, anuin mo ang itong mga party, kindly review further, ha?
Yes, Your Honor.
Now, on forum shopping, what are the consequences of a willful and deliberate violation of the rules on forum shopping?
Your Honor, the case may be dismissed on the ground of forum shopping, and an administrative case may be filed against the party found to have resorted to forum shopping, Your Honor.
Shall the dismissal be with prejudice or without prejudice?
I think it's without prejudice, Your Honor.
It's with prejudice.
Okay, I stand corrected, Your Honor.
And a few, about 2 or 3 doctrines on constitution and politics, political law. What do you understand by the constitutional supremacy doctrine?
As I understood it, Your Honor, it's the Constitution, Your Honor, is the fundamental law of the land.
Yes.
All laws emanate from the Constitution, Your Honor.
Yes, and what happens if there is any violation to it?
It may be questioned before the Supreme Court, Your Honor.
And what happens next?
it may be considered or declared by the Supreme Court as unconstitutional, Your Honor.
And therefore,
And therefore, it has no effect, Your Honor.
null and void. Okay.
Yes, Your Honor.
Supposing the violation was done by the executive branch, what happens?
Yes, Your
What happens?
It be the law which is declared as unconstitutional may be struck down. Well, it can be struck down by the Supreme Court as unconstitutional, and then as I've said earlier, it cannot have the force and effect of a law, Your Honor.
Okay, let's go to judicial review. What are the requisites in order for the Supreme Court can declare that a law is unconstitutional?
Well, if it is contrary to the provisions of the law, Your Honor,
Mhm.
provisions of the Constitution, Your Honor.
There are four requisites.
Oh.
Anyway, ito, mas madali ito. Ano yung doctrine of the fruit of the poisonous tree?
The doctrine of the fruit of a poisonous tree only means that all evidence obtained in violation of the guarantee against unlawful seizure, search and seizure shall be inadmissible in any proceedings, Your Honor, for being the fruit of a poisonous tree, Your Honor.
Okay, Judge, that was my last question. Thank you for your time.
Thank
Good
you,
luck.
sir. Thank you very much. Thank you po. Thank
Okay,
you
good
po.
luck.
Thank you po.
Thank you very much, Your Honor, Judge De Monteverde.
Thank you, Attorney Ann.
Review, Judge Reyes is Honorable Justice Noel Jimenez Dihan.
Thank you, Attorney Ann. Good
Welcome,
afternoon, Judge.
Good afternoon, Your Honor.
How are you?
I'm fine, Your Honor. Hope you're fine too, Your Honor.
Thank you. Judge Reyes inherited my sala in the Regional Trial Court of Quezon City. I left in 2003. You became judge in 2005.
Yes,
and
Your Honor.
You overstayed in Quezon City. You stayed too long in Quezon City. First of all, congratulations, Judge Jocelyn, for a job well done. But you were saying that
Thank you, Your Honor.
you are still continuing the handling of the Maguindanao massacre case?
Yes, Your Honor. Because there are still about 76 accused who are at large. 80 when I promulgated the decision, but after that, 4 accused were apprehended, and there are still 7 or 8 accused. An amended information are still pending, Your Honor, with this court for the additional 7 or 8 accused, Your Honor.
So how can we promote you if you don't want to leave RTC branch 221?
It's not that I don't want to leave RTC 221, Your Honor.
You deserve to be nominated and promoted. But
Thank
I
you, Your
hope you don't
Honor.
get I hope you don't get promoted to the Sandigan Bayan, because are you applying with the Sandigan Bayan?
I am also applying, Your Honor.
You might get a relapse if you go to another trial court.
Um,
So how long did you handle the Maguindanao massacre case? For how many years?
the cases, Your Honor, were referred to me on December 17, 2009. We started the we I started hearing the bail petition on January 5, 2010, and on December 19, 2019, uh,
You promulgated.
I promulgated a consolidated partial decision involving 101 accused, Your Honor.
There were two petitions in the Court of Appeals which I decided relating to the Ampatuan cases. But on hindsight, Judge Jocelyn,
Yes, Your Honor.
had the Supreme Court promulgated special rules to govern the Ampatuan cases, would it have been possible to expedite the proceedings if several judges were designated to receive evidence? On
Uh,
hindsight.
that would have been helpful, Your Honor. It will fast track the decision of the promulgation of the decision, Your Honor. But
And I think
Your Honor, sometime in 2010, Your Honor, the Supreme Court had issued an en banc resolution in order to fast track the case. I was directed to direct the parties to use the judicial affidavit, to resort to the judicial affidavit rule, Your Honor.
but nonetheless, considering the number of prosecution witnesses and the number of defense witnesses, it was indeed a heavy burden to repose that responsibility of hearing the case on only one judge, correct? So had special rules been promulgated by the Supreme Court at that time to allow other judges to receive evidence, to fast track the reception of prosecution evidence as well as defense evidence, considering the numerous persons involved, it would have fast tracked the resolution of the case. Do you anticipate that in the future a similar case may occur in the future? And in your opinion, what other things can be done by the Supreme Court to meet the challenges you met in handling the Ampatuan cases?
I hope, Your Honor, it will not happen again. A similar situation will not happen again, because this involves allegedly 58 victims, but I only included there in my decision 57, Your Honor, because the other one was the other accused. All the accused were acquitted in the 58 case for, well, it might be a sub judice, Your Honor, for failure of there was no corpus delicti, Your Honor.
Refresh my memory, how many accused did you convict in the Patuan cases?
Actually, it involves 101, Your Honor, including seven or eight accused who died already prior to the promulgation of the decision, Your Honor, and several accused were also acquitted by way of demurrer to evidence, Your Honor.
So effectively, how many convicted accused are in detention, more or less?
80 something, Your Honor. 80
Oh, I
something.
see. And
No, I'm sorry,
you
Your Honor,
also,
because I also acquitted several policemen, Your Honor.
but you also determine and impose civil liabilities, correct?
Yes, Your Honor, I did.
It was, and you were assisted solely by your own staff in branch 221.
Yes, Your Honor, but I was assisted, but about last October 2019, Your Honor, I didn't have a legal researcher and a branch clerk of court at the time until
In the
the
event,
promulgation
in
of
the
the
event,
session, Your Honor.
in the event, Judge Jocelyn, that you are nominated and promoted, will there be any impediment or difficulty for your successor in the regional trial court of Quezon City, branch 221, to conclude the resolution of pending Patuan cases and matters?
I don't think so, Your Honor, because as of now, I am only handling 4 accused, Your Honor, after the first batch of the accused, after the decision uh, involving 101 accused, Your
Judge
Honor.
Jocelyn, if an accused in a criminal case refuses to enter a plea, what will happen?
The court will enter a plea of not guilty for the accused, Your Honor.
Supposing the accused pleads guilty but alleges some exculpatory evidence, what will happen?
Well, trial should proceed, Your Honor. It would be, in effect, a
What
self-defense.
happens? What
There
happens
will
to
be a reverse trial, Your Honor, if
what happens
he,
to the plea of guilt? What happens to the plea of guilt? Will it be withdrawn?
ano, Your Honor, but taking into consideration the severity of the case, rather, the seriousness of the crime charged against the accused, the trial must proceed in order for the court to determine whether the plea of guilty was, whether the accused is fully aware of the consequences of his plea, and also in order to determine the civil liability of said accused, Your Honor.
Have you heard about an Alford plea? Alford, Alford,
Alford,
under U.S. jurisprudence. What's an Alford plea?
I have not heard of that, Your Honor.
An Alford plea is when an accused pleads guilty but claims that he is innocent. That's an Alford plea. He is pleading guilty because he does not have evidence to support his defense, but nonetheless he asserts that he is innocent of the crime.
Wouldn't that be
Is
tantamount to for instance, the
is it
case is
similar to a
homicide?
nolo contendere plea? Have you heard about that? A no contest plea
I heard
in criminal.
about that, Your Honor, the no contest plea.
Under Philippine jurisprudence, is that allowed? An Alford plea? I am pleading guilty to the crime, Not because I'm guilty, I'm innocent, but I don't have evidence to prove my defense. That's an Alford plea. Do you think that is allowed under Philippine jurisprudence? Or
It
should it
will
be allowed?
all depend, Your Honor. The court must see to it, Your Honor, that if the accused really doesn't have any defense.
In the Maguindanao massacre cases, there were state witnesses, correct?
Yes, Your Honor.
Supposing an accused in a criminal case was discharged as a state witness, let's say in a case of murder, the question is, may the accused who was discharged as a state witness be prosecuted later for the same crime of murder?
No, Your Honor.
Why not?
Because the law grants immunity by virtue of his being discharged as a state witness. In effect, there's already an immunity.
Is there jeopardy in that case?
I
An
think
accused,
there would be, Your Honor.
accused is charged as a state witness. But later on, the the prosecution changed its mind and prosecuted him for murder. Can he claim double jeopardy?
I think so, Your Honor. The
Why
government
is
should
there
not be
double
allowed to
jeopardy?
do that, Your Honor, to prosecute the state witness.
But why is there double jeopardy? Does it fall under the definition of double jeopardy?
Well, strictly speaking, no, Your Honor, because there was the elements of double jeopardy. You have to prove the elements of double jeopardy, Your Honor, before you
What
can
about the
invoke that.
discharge? What about the discharge of the accused as a state witness? Does it not operate as an acquittal that will fall under double jeopardy?
I don't think so, Your Honor, because there was no actual trial conducted as against the accused who was discharged as a state witness, Your Honor.
The general rule is if the accused consented to the dismissal, to the termination of the case, there is no double jeopardy, correct? That's the general rule.
Yes, Your Honor.
Is there an exception? Can you think of an exception? So, general rule, if the case was dismissed and the accused consented to the dismissal, there is no double
What kind of
jeopardy.
what kind of dismissal, Your Honor?
There was no prior jeopardy, correct? Can you think of an exception?
Is that was the dismissal permanent, Your Honor?
Okay, you make the distinction. So the general rule is,
yes, Your Honor.
That was with the consent, there is no double jeopardy because you consented, okay?
Yes, Your Honor.
But the accused consented. But are there exceptions under Rule 119? What about the mirror to evidence?
The mirror to evidence, Your Honor, is tantamount to an acquittal. It's considered as a trial on the merits, Your Honor.
And it is with the express consent, correct? Express consent.
Yes, Your Honor.
So that
Yes,
is
Your
one of
Honor.
the. What is another exception? Under Rule 119. denial of the accused right to a speedy trial.
Oh, okay, Your Honor. Yes, Your Honor.
Will you be comfortable going to an appellate court where the court is collegial? It will be a different environment, a different workplace, an altogether different method of adjudication.
That would be
Are you,
okay with me, Your Honor. For
are
career
you prepared?
advancement, Your Honor.
Are you prepared to participate in judicial adjudication in a appellate court where the decision making is collegial? Do you think it's better if it's collegial?
Yes, Your Honor. I think I can easily adapt to that.
And you have no problems if you are the ponente, the assigned justice to decide the case, and there is a dissenting opinion? What will be your attitude towards a dissenting opinion?
If that is the personal opinion of my colleague, Your Honor, I think I have to respect it, Your Honor.
You have to respect it. And you have
As long as I
no,
am able to justify my finding, Your Honor, that's okay
and you
with
have no
me.
reservations. You have no reservations as well to make a dissenting opinion to
Yes,
somebody else, ponensya.
yes, Your Honor. I don't have any reservation, Your Honor.
Okay. So if you're appointed to the Court of Appeals, you have no reservations about being assigned in Mindanao?
That's
That's
fine
where the
with me.
Patuans are.
That's fine with me, Your Honor. My children are already grown up.
That's where the Patuans are, isn't it?
Uh, uh, no, Your Honor, it's in Maguindanao. I think it's about
I-
4 hours.
that's still in Mindanao.
Yes, Your Honor. Yes, Your Honor.
So you will request the Chief Justice if you are appointed to assign you instead in Cebu, the Visayas. All right, that's my last question, Judge Jocelyn. Thank you for your time. Congratulations again, and good luck.
Thank you. Thank you, Your Honor. Thank you very much.
Thank you, Justice Noel G.T. Ham. The next to propound probing questions to Judge Solis Reyes will be Honorable Judge Toribio E. Ilaw. Your Honor. Judge Ilaw.
Yes, I'm here. Correct. Thank you. You are, ano pangalan nga pa?
Jocelyn Reyes, Your Honor.
No, our moderator.
Okay.
Yes, Judge, how are you today?
I feel fine,
Jocelyn
Your
Arpon.
Honor.
Your mother's family name is Arpon.
Yes,
I
Your
still
Honor.
remember. We had an airman who became a national or Olympic team member in shooting. You remember any relation to Corporal Arpon at the time? It was way back in 1950s or 60s. It's also from Cebu.
The Arpon, Your Honor, my mother is from Leyte, Your Honor.
Leyte. So,
It's my father
Waray.
who is from Cebu.
Right. Erata could have gone over your PDS and also with respect to your SALN. Could you explain the discrepancy in the amount of cash deposits declared in your 2019 SALN and PDS? Because the amount you declared in 2019 SALN is approximately 2.3 million, while in PDS the amount is around 500,000 only. Could you explain?
Can I have that again, Your Honor? In the sal, and that includes the cash. Most probably that includes the deposit of my husband.
Deposit of your husband. What is the occupation of means of living of your husband?
He has already retired, Your Honor.
He's already 81 years old.
Yes, Your Honor.
Already retired. What was then his occupation?
He used to work in a bank when he was in the United States. And then when he resigned, he decided to venture into a small business, Your Honor, in the U.S.
All right, Judge, how have you embodied the principle of integrity in your entire legal career?
Well, I see to it that in everything I do, I observe honesty, truthfulness, and adherence to the rule of law, Your Honor.
Were you not aware of the administrative case for alleged gross misconduct filed against you on March 29, 2009 by a certain Banhua U. Flores? You did not declare this in your PDS.
I did not declare that, Your Honor, because I was not asked by the Supreme Court to comment on that. I think I only heard about it when the resolution of the Supreme Court was when I received the resolution of the Supreme Court. I also did not declare that, Your Honor, because it has been more than a decade when that case was filed against me. I was not even aware of that, Your Honor.
Were you not required by the JBC to disclose past and present administrative cases, criminal cases, civil cases, any derogatory record?
I disclosed the 3 cases, administrative cases filed against me, Your Honor, and all of them were dismissed by the Supreme Court.
All right. I understand that you penned the Maguindanao massacre cases
Yes, Your Honor.
regarded as the trial of the decade. And I understand that before it was raffled to you, it was raffled to another judge who immediately inhibited himself even before reaching such official information at his court. So it was re-raffled to you. Am I correct?
Yes, Your Honor.
Is it a curse or a blessing?
Well, it's both, I think, Your Honor.
Why both? Why is it a curse?
I don't want to, actually, Your Honor, I don't want to think of it as a curse. But I have said earlier, Your Honor, it's a life-changing experience because first and foremost, my sense of privacy was lost because whenever I do something, especially when I'm outside of the house, guards will always be around me, Your Honor. So that's it, Your Honor.
And why is it a blessing?
Well, it's a blessing in the sense that I was able to encounter motions, which for the first time, which I only heard during the time that I am handling, when I was already handling the Maguindanao massacre cases, Your Honor.
It may be regarded as a blessing because it may culminate in your promotion. You remember the case way back in 1960s, the Maggie de la Riva case, where the magistrate was promoted to be an associate justice of the Court of Appeals. That's Lourdes Paredes San Diego. The case, the then Mayor Sanchez was promoted also. The presiding judge was also promoted. And also the presiding judge who handled and penned the decision in the Webb case.
Your Honor, when the cases were re-raffled to my sala, Your Honor, I did not have that in mind. The promotion was not in my mind at that time, Your Honor. All I wanted was to finish resolving that particular case, Your Honor. The first batch, rather.
The first batch. But it took you how many years from 2009 to render a partial decision on the consolidated cases?
We started hearing the case on January 5, 2010, Your Honor. And we had a gap because of the amendment of informations made by the prosecutors, Your Honor. We had a gap of several months.
All right. By the way, could you tell us how you prepared for such case? Because Taguig, when I was still a presiding judge of Taguig, the Bikutan, it was really a specially designed court for you. While we were also hearing the case of Abu Sayyaf and NPA cases. How did you prepare for the case?
Your Honor, we have a designated day or days to hear the Maguindanao massacre cases. Every Monday it's actually our motion day, and Wednesday and Thursday that's trial on the merits, Your Honor. I jot down whenever we have a hearing. I see to it that I jot down on the important facts testified on the testimony of every witness presented.
All right. Do you think you are better than the other applicants for the positions of either the Court of Associate Justice of the Court of Appeals or Associate Justice of the Sandigan Bayan?
Your Honor, if I say that, that would be self-serving, Your Honor.
We can accept that.
But with all due respect to the other applicants, I think if we have to consider the fact that I have been with the regional trial court for almost 16 years, so I would humbly say that I am better than the other applicants, Your Honor. We all know that experience is the best teacher, Your Honor. So I think having a long experience with the regional trial court, as a judge of the regional trial court, I humbly think that I am better than some of the applicants, Your Honor.
I said, according to Justice Tiham, you're already overstaying in your sala. And there's a saying as government employees who stayed long in the government has the tendency to relax and loss of any motivation for improvement. Do you agree?
I don't Well, with all due respect, I don't agree. I beg to disagree, Your Honor. I still have the motivation, Your Honor, the desire to hone my craft, Your Honor, as dispenser of justice.
All right. It is important for a magistrate to always maintain his her legal acumen to be effective. How do you keep yourself updated with laws and jurisprudence as well as current issues?
I read the latest issuances of the Supreme Court, Your Honor, if I have the time.
In what
And
manner do you read? Do you make use or avail of the online resources to update your or in your legal research?
if there's really a need, Your Honor, to make use of that,
Let's make a test. The question is, can a final and executory judgment in a criminal case be modified on the ground that the penalty imposed was outside the range of the penalty prescribed by law?
under certain circumstances, Your Honor, yes.
Could you explain to this?
Um, a final and executory decision can still be
Yes,
amended, Your Honor.
it's already
Uh,
executory, final and executory.
yes, Your Honor. In order to in order not to prejudice, Your Honor, the other party, to avoid prejudice to the other party, Your Honor, or in cases of non-proton order, Your Honor, it can also be amended, Your Honor.
And what will be the ground for the modification of such judgment? A sentence which imposes upon the defendant in a criminal prosecution a penalty in excess of the maximum which the court is authorized by law to impose for an offense which the defendant was convicted. On what ground?
Well, um, because if we proceed, Your Honor, if the court will proceed with the execution of judgment, Your Honor, that would be prejudicial, Your Honor, to the accused himself because the judgment or the penalty is not within the parameters, or rather, it is not what the law says, Your Honor.
All right, the judgment is void for want or excess of jurisdiction as to the excess. That is in accordance with Bigler versus People GR number 210972, that's March 19, 2016.
Yes, Your Honor.
All right, what are the effects of a final and executory judgment?
The effects of final and executory judgment, Your Honor. Well, the winning party can ask for its execution.
Okay.
But the losing party, Your Honor, can also has a remedy, Your Honor, a legal remedy. he can ask for the losing party can ask for annulment of judgment.
Can the court modify the rights and obligations of the parties which had been adjudicated upon?
If there is newly discovered evidence, Your Honor.
No, the courts are barred from modifying the rights. All right, let's go to another case. Does the office of the special prosecutor possess an independent power to act on behalf of the ombudsman? Because you're eyeing also for a position of the Associate Justice of Sandigan Bayan, where the jurisdiction or most of cases in the Sandigan Bayan are a violation of the anti-graft and corrupt practices.
Can I have the question again, Your Honor?
Does the office of the special prosecutor possess an independent power to act on behalf of the ombudsman?
I think so, Your Honor. No, Your Honor. These special prosecutors are still under the office of the ombudsman, Your Honor. No, Your Honor. The special prosecutors are under the office of the ombudsman.
So you will agree that the office of the special prosecutor is but a mere component of the office of the ombudsman.
Yes, Your Honor.
It does not possess an independent power to act on behalf of the ombudsman.
Your Honor,
That's
can I
only
have that
upon
again?
the ombudsman.
I'm sorry, can I have that again?
It does not possess an independent power to act on behalf of the ombudsman. Only
On behalf of the ombudsman, Your Honor. It is
Yes,
under the ombudsman, Your Honor.
Yes. But it's not an independent, it has no independent power to act on behalf of the ombudsman.
Yes, Your Honor.
Right. Let's go to another to civil case. What is a dragnet clause? Or kakunot na naman ang noo mo, Judge. Already 60 years. So. Dragnet clause. It's more or less.
A dragnet clause is, I think, an encompassing clause, Your Honor, if I'm not mistaken.
Encompassing clause.
Yes, Your Honor.
Where, when, and how?
As I understood it, Your Honor, both in civil and criminal cases, Your Honor. Sorry, in civil cases, Your Honor.
Civil case only.
Yes, civil case.
All right, let's go to labor case. Okay. When is there a labor-only contracting?
There is only labor-only contracting, Your Honor, if only the services are being offered by the employer to the client. The subject, Your Honor, is the services of the services being offered by the employer to a specific client, Your Honor.
All right, my time is running out. Only 2 questions remaining for me. Tell us about a personal accomplishment that you are the proudest of.
I am proud.
Personal accomplishment that you are the proudest of?
I am just happy, Your Honor, that I was able to. I'm not really proud, Your Honor, but I am just relieved. I am happy that I was able to decide the Maguindanao massacre cases after several years, Your Honor.
But that is your professional accomplishment. I'm asking you about your personal accomplishment.
A personal accomplishment? Well, I think I am a good mother, Your Honor, and I am taking care of my family, Your Honor, and I am able to provide for my family without relying completely on my husband, Your Honor. For me, that is my personal accomplishment, Your Honor. One of my personal accomplishments.
All right, my last question, and this is a psychological one. How do you design a spice rack to a blind person?
What is that again, Your Honor? I didn't quite get that.
How do you design a spice rack?
Oh, yes, Your Honor.
To a blind person?
Well, I will just describe to that person that this is the spice rack that I will be making, Your Honor, and I will tell that person that I will place here the following spices so that he will not or she will not be misled, Your Honor. I will first assist the person, Your Honor, so that he will not be misled.
Without avoiding sneezing?
Without.
How will he avoid or she will avoid sneezing?
I'll see to it that it is covered, Your Honor. The spices are covered.
Spices are covered.
Yes, Your Honor.
All right. Thank you. That was my last and final question. Good luck. Masyado ka na seryoso talaga, Judge.
Thank you, Your Honor.
Okay, welcome. Thank you too, and good luck again.
Thank you po.
Thank you, Your Honor, Judge Ilaw. May we now turn over the conduct of the interview to Honorable Justice Jose Catral Mendoza.
Thank you.
Just Attorney Ann, the Chief Justice is here po, and he wants to ask questions to Judge Solis.
Hello.
Before
Chief
Justice
Justice,
Mendoza.
Yes po.
Yes,
before Justice.
Before
Justice Mendoza.
Sige, I'm adapting the questions. Hello.
Yes po.
Hello. I'm adapting the questions posed by my colleagues, and I have no more further questions. I'm giving way to the Chief Justice.
Thank you.
Good afternoon, Your Honor.
Thank you.
Good afternoon,
for
Chief.
giving me the time. Just Manong Bambik, no. Just ask some questions. No? Just few questions.
Good afternoon, Chief.
Yeah. Good afternoon, Jocelyn. No. Just few questions. No. My first question is, when that case of Patuan was filed in Quezon City, who was the first judge that was assigned to handle the case of Patuan? Were you the first one who was supposed to, were you the first one assigned to handle the case of the Patuans?
No, Your Honor. Said cases were merely raffled to my sala, Your Honor.
Yeah, but before it was raffled to your sala, where was there a judge raffled? Was there a judge ahead of you where the case was raffled?
Yes, Your Honor.
So how many judges? How many judges? Only one or two or three judges?
Only one, Your Honor.
So the first judge to whom the case was assigned inhibited or inhibited due to voluntary inhibition or mandatory inhibition?
It was, I think it was a voluntary inhibition on his part, Your Honor. But he was
Uh,
able to explain his side, Your Honor, in making the voluntary inhibition, Your Honor.
I remember one of the reasons that he feared for his life and the life of his family. Because
I think so, Your Honor.
Because the report that reached us is that even before the case was transmitted, or the records were transmitted to his sala, he already inhibited himself. Before, you're not sure, but you are sure that he inhibited himself, and then the case was raffled to your sala.
Yes, Your Honor.
What did you feel when the cases were assigned to you with too many accused and then too many victims, no? And a girl judge like you, what did you feel when the cases were assigned to you?
I did not feel happy about it, Your Honor. But
So you were sad. You were sad. Was there a time that
I would say that I felt sad about it, but since it's my duty to accept cases as raffled to me, assigned to me through raffle, then I accepted it, Your Honor.
Yeah. So you did not feel frightened considering the personalities involved and the number of victims when the cases were assigned to you?
I think it was only normal. It is only normal to feel frightened, but I am a judge, so I'm not supposed to think about that. I needed to set that aside, Your Honor.
Yeah. Now, it took you, I think, more than 10 years to finish the cases.
Your Honor, less than 10 years, Your Honor.
So not less than 10 years, but a little more than 9 years, I think. That will include the promulgation. I'm not saying the termination of the trial, but including the promulgation, it took you somewhere from 9 to 10 years, right?
Yes, Your Honor.
But there were some reports that you were not too fast to resolve the cases because it took you more than 9 years to finish the cases. And what can you say about that?
That's their opinion, but I think I did my best, Your Honor, in order to fast track the cases.
And during the time that you were handling these cases, and these are they consider these cases as a trial of the century. That's what we read, what we have read from the papers. Did you feel disturbed, or did you feel that someday or during the time of the trial something might happen to you?
I did not think about that, Your Honor.
We're getting not that violence will be committed against you, but it might affect your health.
It did, Your Honor. It did.
In what form?
I suffered. I am suffering gastritis, Your Honor, until now, gastritis, and I was told by my doctor it's because of stress, too much stress.
And
handling these cases is really, Your Honor, stressful.
Stressful. Now, you have been with the judiciary for so many years, starting as an MTC judge in 2004, I think.
2001, Your Honor.
Yeah, 2001.
Yes, Your Honor. Almost 20 years.
Yeah, and
by next year.
You have been an RTC judge for 15 years.
More than 15 years, Your Honor.
So all in all, how many years with the judiciary as a judge?
Almost, more than 19 years, Your Honor.
more than 19 years. And within the 15 years that you were an RTC judge, you must have been already available for recommendation or for nomination as an RTC judge during the time that you were trying the cases of the Patuans. Am I correct? Because you stayed as an RTC judge for 15 years. So probably you were already qualified for the position of RTC judge because of the length of service. Did you understand what I mean?
I did not quite get that, Your Honor. I
Okay,
did
it's
not
like
hear
this.
it.
You have been in the service for so many years,
Yes, Your Honor.
and more than 15 years in the RTC.
Yes, Your Honor.
So during the period that you were trying the case of the Patuans, you were already qualified to be a candidate for the Court of Appeals.
Yes, Your Honor.
Because 15 years. No? Did you have any reservations then that to the effect that it could have been better for you to give up the cases because within that period you were already qualified to
Yes, Your
become
Honor.
Justice of the Court of Appeals? Do you get my point?
Yes, Your Honor.
There was a time that was there a time that you regretted handling the cases of Patuan because you lost that opportunity to be nominated or to be recommended for this position of a Justice of the Court of Appeals.
Actually, Your Honor, in 2016, I applied for promotion. And then I was also, I was not included in the shortlist. And then in 2019, when there were 8 vacancies in the Court of Appeals, I prepared myself I prepared all the documents needed for me to apply for the position. But I decided not to because I felt then that I needed to finish first handling these cases, and applying for a promotion is something which can be set aside in the meantime, Your Honor.
So in other words, it was really your duty, no? It was really your duty. It's in other words, duty first before promotion.
Yes, that's correct, Your Honor.
Yeah. Now, you have been handling this case for 10 years, but your application is not only for the Sandigan Bayan, where all the cases are criminal cases, but you're also applying for the vacancy in the Court of Appeals and in the Court of Tax Appeals. Did I get you right?
Sandigan Bayan, Your Honor, and Court of Appeals. I did not
No,
apply for CTA, Your Honor.
Okay, so
Yes, Your Honor.
anyway, you go to Sandigan Bayan, probably you tell yourself, I'm very much prepared because I've been handling criminal cases, especially the Patuan, for more than 9 years. No? Now, what about in your application for the Court of Appeals? You'll be handling a lot of cases, not only criminal cases, but probably civil cases, labor cases, all of those cases that are brought to the Court of Appeals on appeal and even under certiorari. So do you think that you are also prepared and therefore ready to perform the duties of a Court of Appeals justice? Considering that your background is more on criminal cases?
In my humble opinion, Your Honor, I am also prepared.
You're also prepared.
Yes, Your Honor.
Can you assure us that you will perform the same dedication to your work as an appellate court justice or something, the same dedication that you put for yourself in handling the cases of the Patuan?
Yes, Your Honor. I can always assure Your Honor.
Or because that you have already terminated the case of Patuan, so it's high time that I should be promoted.
I'm still handling, Your Honor, the Maguindanao massacre cases.
Yeah, for those who have not been arrested, but the main accused and most of the accused cases have already been terminated. That's
Yes, Your
correct.
Honor. The first batch,
You're
Your
handling
Honor.
cases those that have been arrested, no?
Yes,
Or
Your
those
Honor.
accused where the court has already acquired jurisdiction over them, right after we have promulgated the cases involving the masterminds and the other accused.
Yes, Your Honor.
Okay. So can you promise us that you will give the same dedication?
I promise, Your Honor, and I am always dedicated to I have always been dedicated, Your Honor, to my
Okay.
sworn duty.
Okay. Now, my last question is this, Judge Jocelyn. Do you have a family?
I have a family, Your Honor.
How many children do you have? Do
Your
you
Honor?
have children? You have children?
I have children, Your Honor. They are all grown up.
Yeah. What did they feel when you were handling all these cases? Probably there were times that you were not with your family. You were separated from your family for some time because of the cases that you have handled. How did they
Yes.
feel when
Well,
during this period?
at first, Your Honor, they didn't feel comfortable about it. They felt sad. They were still in elementary, Your Honor, when the cases were raffled to my sala, Your Honor.
Now they are in college.
Now,
They are working now, probably.
not yet working, Your Honor, but they have already finished their courses, Your Honor.
So probably they are now praying very much for your promotion.
Most probably, Your Honor.
You know, they should be praying. So anyway, so you're applying only in the Sandigan Bayan and in the Court of Appeal. Now the work in the Sandigan Bayan and in the Court of Appeals is different from the work of a judge because you alone decide the cases, no?
Yes, Your
Whereas
Honor.
in the two courts it is collegial. In other words, your decision is also the decision of the other two.
Yes,
Can
Your Honor.
you, with all these cases that you have been handling in RTC judge, can you easily adjust to the work of a collegial body?
I think so, Your Honor.
Was there a time that you worked with some of your colleagues, like formulation of rules or guidelines, where decisions were made by a collegial body? Do you have an experience?
I used to have my assisting judge, Your Honor.
Okay.
Yes, Your Honor.
Okay. So that's all. Good luck, Judge Jocelyn. I do not know you're a graduate of UST. Were you my former student ba?
Yes, Your Honor.
Ganun ba? Matanda na pala ako. Anong year yan?
When I was in first or second year, Your Honor.
Wow. I was still teaching Roman law and legal bibliography probably.
Transportation, Your Honor. You were my professor.
Yeah, okay. I shifted already to better subjects. So that's all. That's all for me. So thank you very much, Jocelyn. Good luck and Merry Christmas.
Merry
And
Christmas
happy,
too, and thank you
good-
very much, Your Honor.
Good luck to your family also. Okay?
Thank you. Thank you, po.
That's all. Yeah.
Thank you very much, Your Honor, Chief Justice
Yes.
Peralta. Thank you also, Judge Reyes. We bid you good luck. Your Honors, that brings to an end the 9th of the 13-day series of public interviews of aspirants for a seat in the appellate courts. We shall resume this coming Friday, December 18 at 9 o'clock in the morning. Thank you very much and